And first of all, obviously, welcome everyone to joining this latest in the series of Cornerstone Housing webinars. I was just checking what we've already done this year. We've had a housing allocations webinar, a modern approach to disrepair, the best use of injunctions, and post-IMAM webinars so far. So this is the fifth one in the series, and towards the end of this morning's session, I'll mention a couple of events coming up as well. So there are still lots of things to be doing this year. But as I say, welcome everyone for joining. We decided to do something on shared ownership, not just because I'm a little bit obsessed by it at the moment, because of a recent judgment, which I will mention later, but also because it tends to fall through the net a bit when people start thinking about possession actions generally and how to deal with certain types of problems, whether that's rent, whether that's subletting, whether that's antisocial behaviour or damage to the property or whatever. People don't seem to reference that to shared ownership, and sometimes that's very obvious because it's often the same process, but sometimes it's not. And we really wanted to make it clear where some of the issues are and where maybe some of the controversies are coming up. It is a sector which is growing. I think it's something like 1% of all households are shared owners. Although in principle, any tenant of a housing association would be able to ask to be a shared ownership. They have a right to shared ownership in general terms, as long as they satisfy certain conditions. But it's still a lot of people, although, as I say, only 1% of households are shared ownership tenants. If I can get it working, you have, well, unfortunately, in terms of the middle one, you have the pictures of us there showing who's speaking today. So we have on the left, as you look at it, we have Dr. Lois Lane, who was called in 2022. She had the misfortune to be my pupil, but also had some much better pupil supervisors before that, so before she's on her feet. Lois does a lot of work in the planning and environmental and climate change field, but also deals with issues to do with housing and licensing, local government and ADR. And one of the things you'll notice about both my co-speakers is that when you go on their websites, you'll see that they have various awards and scholarships. I think Lois has 8 and India has 9. You'll see on mine, I don't even have that as a category. So I think that tells you everything you need to know. The only other thing I'd say about Lois is that she started off her academic life as a historian, and therefore can give a good background of most things. So welcome, obviously, to Lois speaking today. The other speaker who's on the right, as you look at, is India Flanagan, who's a 2018 call. India practices primarily in court protection, but also deals with a lot of housing work, licensing work, information law and property work, and as I say, it's increasingly kind of been involved in the housing field. If you have any questions, and we had one question before when people were booking in to this event over the last couple of weeks, but if you have any questions, hopefully you have access to either the chat or the Q&A section, and the person who's not speaking will either answer any questions you have, or towards the end, we will answer it when we have the time for questions and answers. In terms of, before moving on to Lois, in terms of what we're hoping to gain out of today, if I can get this working, the next slide. Key takeaways. Shared ownership agreements are, as you probably know, but you'll certainly find out, are a hybrid product. It's not a simple case like an assured tenancy or a secure tenancy for periodic tenants is. In principle, again, as you'll see, they operate like any other assured tenancy, pausing there to say that there are still some local authority shared ownership tenants, but the major market is with housing associations. And one of the issues I'll be dealing with is the question about how to charge rent and whether recent case law has changed how that must happen. And there's also been certain people who want to also argue that you should only seek possession of a shared ownership tenancy by reason of forfeiture and not through the Housing Act 1988. And both Lois, India, and myself will be discussing those issues as we go through it. And finally, just in the very quick look to the future, we'll just be making the point that a lot of what we'll say today, certainly for new shared ownerships, tenants coming forward, may well be old-fashioned and obsolete. Although I suspect what a lot of what we're saying will still apply to a lot of tenants as matters presently stand. So hopefully at the end of it, you'll have an idea of what happens in practice and also what we may expect to see in the next, well, I think at the moment, I saw something today saying it could be the next 6 months that we could see something with the Renters' Rights Bill. So if I can then move on to Lois, and she will deal with the question of what is shared ownership. Over to you, Lois.
Fantastic. Thank you very much, Andy, for that very kind introduction. And I'm hoping that we'll be able to seamlessly work the technology to move slides along from London while I dial into this webinar from up in the northwest of England. So what is shared ownership? Shared ownership is often referred to as the fourth tenure, or as as Andy said, a hybrid product. It's sometimes referred to as being part own, part rent, and all of these are not untrue, but they don't necessarily tell the full story. So shared ownership in the form that we know it today was introduced in 1980 through the Housing Act 1980. So it's been around for quite a long time, but it's really gathered pace in the last couple of decades as a really sort of viable tenure for a lot of households. But the first thing to note about shared ownership is that it is, in fact, notwithstanding the name, a type of assured tenancy. Shared owners have a fixed term, assured shorthold tenancy with a landlord. And as we've heard, that landlord is usually a housing association, although there are some local authorities that offer shared ownership, and there are also some private for-profit providers that offer shared ownership tenancies. So don't be fooled by the fact that these are assured shorthold tenancies. The fixed term is equal to the term of the lease, and these are, in fact, long leases. We'll come back to the details of how this works from a legal perspective in just a moment. But the important thing to note, these are assured tenancies, they're also long leases. And the principle behind how shared ownership works is that the shared owner will pay a premium for that lease, and that premium is set at a proportion of the value of the property. And so they're effectively purchasing a share of the equity in the property. Usually this will happen via a mortgage, and the idea is that because the shared owner is only paying a premium on a proportion of the value of the property, it's a more affordable route into ownership than buying a home outright. It allows people to get on the property ladder with a smaller deposit and a smaller mortgage than they would otherwise require. And in addition to the premium on the lease, the shared owner will also then pay a subsidised rent on the remaining share of the value of the property. The freehold, or this time, while the shares are kind of not complete, the freehold remains with the landlord. And over time, shared owners can purchase additional equity in the property in increments, potentially all the way up to 100%. And this is an important part of shared ownership as a tenure. It's a concept known as staircasing, and it's really the unique selling point of shared ownership as a model of home occupation. So, as Andy touched on in the introduction, there are currently a little over 200,000 households in the UK living in shared ownership properties. In fact, pardon me, not even the UK, just in England. So the English Housing Survey for 2019 to 20 that DLUC carried out found that there were 202,000 households at that point in shared ownership. It's probably a little more than that now. So we're looking at a really considerable number of properties and households. It's around 1% of all homeowners. It's still a little bit less than 1% of all households at the moment, but it's climbing year on year. And following consultations in 2019 and 2020, the government announced that there would be a new national model for shared ownership homes that were funded via the Affordable Homes Programme that is run by Homes England. And at that stage, a number of reforms were put in place to how shared ownership works. So the key features of those reforms were first that the minimum initial share that a shared ownership tenant could purchase in the property was reduced. Prior to 2021, the minimum share was 25%. In April 2021, that was reduced to 10%. So again, just really pushing that barrier down to the barrier to entry for this type of tenure. So the minimum share now is 10%, but the English Housing Survey, again in 2019 to 20, found that at that stage, the average initial share that was somewhere around 40%, a little over 40%. So on average, most shared ownership tenants looking at purchasing somewhere in the region of between, well, 10 and 75%, but 40% being the average for an initial share. Another change since the 2021 reforms is that new shared owners now can buy additional shares in their home in increments of 1% for the first 15 years. And so again, that is the design behind that was to lower the barrier to staircasing and to mean that people didn't have to save up in the first sort of 10, 15 years of their shared ownership tenancy, didn't have to save up large amounts of additional equity or get large amounts of additional mortgage finance in place. It also reduced the fees that were chargeable when staircasing. So again, all of these reforms designed to try and make it easier for people to buy in the first place and then to increase their stake in the property over time. Again, new in 2021, the cost of maintenance and repairs, which used to fall on the tenant, are now covered by the landlord for the first 10 years after the purchase of a new property, although there are some limits on that we can address perhaps in the Q&A if people have specific questions around that. But again, it just all of these reforms designed to lower that barrier to entry. And the final really crucial reform was that the minimum term for the lease on a shared ownership property was extended. It used to be 99 years and now it's 999 years. So that's a big change. Now, all of these refer to shared ownership properties that are financed in part by grant funding through the Affordable Homes Programme. That doesn't cover absolutely every shared ownership property, but it is the bulk of them. And certainly the vast majority of housing association properties that we're talking about here will be funded partly through private finance, through Section 106 contributions, but also by government grant funding through the Affordable Homes Programme. And it's that grant funding that allows shared ownership landlords to charge that subsidised rent on the share of the equity in the property that the shared owner hasn't paid the premium towards. So it's the grant funding that allows this to be a more affordable option for shared owners. Like other forms of affordable housing, or pardon me, like other leaseholds rather, there will be service charges that will apply to shared owners exactly as they would to any other leaseholder. So that's another thing to bear in mind in terms of charges that are leviable. But moving on, we've talked about this being a hybrid model, and you might find yourself asking, so if we're talking here about leases that are 990 years long, potentially, how on earth can this form of tenure be called an assured shorthold tenancy? How can it be both a long lease and an assured tenancy? It feels a bit strange for something to be both of those things at once. But if we take a look at Schedule 1 to the Housing Act 1988, this sets out a range of exceptions on types of tenancy that can't be assured tenancies. And we find that, in fact, there is no explicit exception here around long leases. There's no explicit restriction anywhere in this schedule on what the upper limit is for the period that an assured fixed-term tenancy can be for. And so there is nothing in that schedule to say that an assured short-hold tenancy can't be for a 990-year fixed-term period. Now, the usual exception that would catch long leases generally for residential leaseholders who are not shared owners is found in paragraph 3A of that schedule. And this is the exception for tenancies at a low rent. And at the moment, that exception sets the threshold for a low rent at £1,000 per annum for Greater London and £250 per annum elsewhere. So for normal residential leaseholders, that would kind of tend to exclude their long leases from being assured tenancies. However, that exception doesn't operate in relation to shared ownership tenancies. So, in short, there's nothing in this schedule that says that a long lease shared ownership tenancy can't also be an assured tenancy. And in fact, shared ownership tenancies they're a hybrid model. And they are also, in addition to being assured tenancies for the purposes of the 1988 Act, they are long leases for the purposes of Section 76 of the Commonhold and Leasehold Reform Act. And they meet all of the criteria in Section 76 for a long lease. There was a recent Court of Appeal decision, and I'm sure that Andy may well come back to this later on in this webinar, but recent decision in Avon Ground Rents Ltd and Canary Gateway, which confirmed, the Court of Appeal confirmed in that case that yes, it was definitely the case that shared ownership leases were long leases for the purposes of Section 76. And that was true even in circumstances where the shared owner had not yet staircased up to 100% of the value of the property. And so the final point to make on the general question of what is shared ownership is that because shared ownership tenancies are assured short-hold tenancies, all of the usual provisions in the 1988 Act around security of tenure apply to shared ownership tenancies as they would to other assured tenancies. And that means in particular that at least one shared owner in the case of joint tenancies, or the shared owner in the case of sole tenancies, must occupy the property as their only or principal home. If they cease to do that, then they will lose their security of tenure in the same way that an assured tenant would lose security of tenure if they cease to occupy a property as their only or principal home. And that was confirmed by the High Court in the case that you can see on your screen at the moment of Alexander's Buka Yulia Tanusi and Metropolitan Housing Trust Limited, which was a case a couple of years ago. And in that case, Mrs. Justice Hill clarified that the conditions that one or more shared joint tenants must occupy the property as their only or principal home, that did also apply to shared ownership. Now, in terms of what that means for possession proceedings, it means different things depending on whether or not security of tenure has been lost. We'll turn to that in just a moment, but it's important to remember that because these are assured tenancies, they behave in a lot of ways like a standard assured tenancy would behave. So That's a whistle-stop tour through the basic mechanics of shared ownership tenancies. I'm now going to hand over to India Flanagan, who is going to give us an overview of how possession proceedings work in the context of shared ownership. Take it away, India.
Thank you, Lois. Good morning, all. As Lois and Andy have both explained, I will be discussing with you how landlords seek possession. If we go to the first slide, so as Lois has already explained, shared ownership leases, despite them being long leases, given the fact that they're a hybrid model, can also be assured tenancies. And as Andy has also said, whilst the majority of tenancies fall under the 1988 Act, there are still a few local authority ones, which of course would then come under the 1985 Act. But if we focus primarily on the 1988 Act, the standard principles in relation to how you seek possession for assured tenancies will apply. So, for example, when security of tenure is retained, you first, of course, need to apply with the standard principles of the pre-action protocol, and this will usually be the social housing pre-action protocol, which I will discuss shortly in the next slide. To start possession proceedings, the basic principles apply, that you must serve a notice seeking possession. And then, of course, you must issue a Part 7 possession claim. So just a few factors which I think are useful, always useful guiding points for the NOS, for example. Of course, it is very important that with any possession claim, you must ensure that the NOS clearly sets out the grounds under Schedule 2 of the 88 Act, which you wish to rely on. Of course, the mandatory grounds are grounds 1 to 8, or of course, the discretionary grounds are grounds 9 to 17. And in respect of other principles, because if there's joint tenants, they must all be named on the notice. In terms of the material dates, you must ensure that all material dates are included for a Section 8 notice. You must give the date before which the proceedings may not be issued, and of course the date after which proceedings may not be issued, normally 12 months after date of service. And you still need to ensure that, dependent on the ground that you rely on, you need to comply with all service requirements. And again, this depends on the ground. So, for example, ground 7A, conviction for serious offences, the notice must be served within a specified period. And then the general procedure in respect of a Part 7 possession claim would apply, therefore, where the court may not make an order, save for a ground being satisfied in Schedule 2, and the landlord needs to prove that ground has been satisfied. The situation, of course, is different if you have lost security of tenure. So whilst not directly relevant for shared ownership leases, just by way of context, of course, tenants who have introductory starter tenancies won't, of course, have security of tenure, or if you sublet, which I will discuss later on, you can lose your security of tenure. But for shared ownership, as Lois has already set out, you do have security of tenure for as long as that tenant lives in the home as their only or principal home. And again, for joint tenancy, one of you must, of course, live in the property as the principal home. For situations when you lose security of tenure, a notice to quit does not apply, as that, of course, is only for periodic tenancies. So in order, in this case, to bring a tenancy to an end, you must either go under a surrender or an eviction. If you evict, the NOS will apply whilst you remain a short-hold tenant, and if that is not the case and you don't remain in the property, you must go down the forfeiture process, and that's for long leases. And of course, for forfeiture proceedings, you must have a declaration of breach. which does apply unless there are rent arrears. And then for forfeiture proceedings, you must issue a section 146 notice. And again, this all applies apart from when there are rent arrears. And in terms of the requirements, similar to the NOS, you must always ensure that all requirements in your section 146 notice are complied with. So, for example, it's very important that you specify the breach that you allege does arise. If the breach is capable of remedy, you must require the leaseholder to remedy that breach. And in any case, you must require the leaseholder to make compensation. So the leaseholder is afforded a reasonable time to remedy the breach if it's capable of remedy following the service of a 146 notice. And again, as I'm sure everyone is aware, that the court's proceeding cannot be commenced unless the leaseholder fails within a reasonable time to remedy the breach if it is capable of being remedied. If going forward, the proceedings continue, then you must, of course, also ensure that you make reasonable compensation in monetary terms for the breach to the satisfaction of the landlord. I wish to discuss in a little further detail about the requirements for the application of the various pre-action protocols. Thank you, Andy. So in respect of the pre-action protocols, there is of course some debate for shared ownership leases as to which pre-action protocol applies. So as Lois has already discussed, whether arguably, because the shared ownership is a long lease, it is arguable at least if the pre-action protocol for possession claims by social landlords apply. But in any event, to err on the side of caution, you can follow the principles in the social landlord pre-action protocol. But if you're not sure, of course, the general principles of the practice direction pre-action conduct and protocols apply. So starting on that protocol, of course, as you can see on the slide, paragraph 6 very clearly sets out that if there is a relevant PAC, you must use that one. If no protocol, use this pre-action protocol, and this sets out the steps that you must take before issuing a claim. And the burden, of course, will always be on the claimant to prove that all steps have been taken. The current version of the social landlord pre-action protocol is the protocol that's been enforced since the 13th of January 2020. It applies to all residential possession claims by social landlords. And as I've said, there is some argument as to whether or not the social landlord pre-action protocol applies, because it doesn't apply to long leases. And again, going back to Lois's helpful introduction, shared ownership leases now can be 999 years. And again, as I've said with the NOS, make sure that you comply with all various aspects of the pre-action protocol. Of course, part 3 sets out clear considerations for when you are bringing a possession claim on mandatory grounds. And of course, part 3 deals with certain criteria that you need to be mindful of when there's a potential Article 8 claim. If we go forward, thank you, Andy, that's much appreciated. In respect of section 7.6 of the 88 Act, the reason we wish to draw this to your attention, of course, is that this is an important section where it relates to forfeiture clauses in leases. And section 7.6 sets out that there are certain grounds that you cannot, that you can rely on. And here the court says the court shall not make an order for possession to take effect at a time where it's let on an assured fixed term tenancy, unless the possession is on the basis of mandatory grounds 2, 7A, 7B or 8, or a discretionary ground other than grounds 9 and 16. So just to reiterate, you cannot rely on grounds 9 and 16. in respect of ground 2, that relates to mortgages, 7A is the mandatory ground. 9, of course, wouldn't arguably be relevant in shared ownership cases because it refers to suitable alternative accommodation. And ground 16, again, arguably wouldn't apply in any event because it relates to employment situations. But the assured tenancy or assured shorthold tenancy must make express provision that the tenancy can be brought to an end on the ground by way of, for example, forfeiture notice or any other provision. And if we go further into talking about subletting, and in terms of section 15A of the 1988 Act, and this refers to shared ownership agreements. So as Lois has already said about staircasing, shared ownership agreements, which have not been staircased to 100%, are covered by both the Housing Act 1988, for example, if the tenant is an assured tenant, and also the Commonhold and Leasehold Reform Act 2002, the 2002 Act. So what does section 15A say in the broadest terms? And essentially what it means is if an assured tenant sublets or parts with possession of the dwelling house, the tenancy ceases to be an assured tenancy and cannot subsequently become an assured tenancy. So essentially, of course, that means if an assured tenant sublets the property or does not occupy it as its only or principal home, it loses security, the tenant loses security of tenure and cannot regain that security of tenure back. However, it's very important to recognise that section 15A does not apply to a shared ownership lease. And section 15A essentially allows this forfeiture clause to apply on the basis of an express term, so if that's expressly set out in the tenancy agreement, but also as an applied term. But because it does not apply to a shared ownership lease, that essentially means that it's very important for landlords to ensure that this clause, or the terms essentially of section 15A, are express terms within the shared ownership lease. Otherwise, this protection that essentially it affords landlords falls away. So it's always very important to remember with section 15A that an implied term here will not be sufficient and will not be effective. And where we can see how the application works is a case of Bedford and Paragon Azra Housing Limited, a 2021 case set out in the upper tribunal. I'll very briefly, just in case you're not familiar with this case, just explain some of the factual background, as I personally found it quite interesting. This was an appeal where the upper tribunal considered an appeal against the first tier tribunal's refusal to strike out an abuse of process. The landlord, strike out as an abuse of process the landlord's application for determination under section 168 of the Commonhold and Leasehold Reform Act 2002 that the tenant breached the covenant prohibiting subletting, which is contained in the shared ownership lease. So Mr. Bedford, he had at that time, as Lois said, before it changed to 999 years, and this time he had a 99-year shared ownership lease from Paragon Azra Housing. The lease contained an absolute covenant which prohibited Mr. Bedford to sublet or underlet the property. However, within a year of the lease commencing, Mr. Bedford, with Paragon's permission, obtained essentially authority to sublet the property for 1 year whilst he was away. And incidentally, for what it's worth, he went away for what he said purportedly was a year to go to the United States to try and be selected to be a member of the United States national rugby team prior to the 2011 World Cup, as you do. And he gave a specific assurance that he would return to the property at the end of 2011. And that did not happen because Mr. Bedford did not return. And it seems to be the case that the property was then sublet since 2010, and Paragon only became aware of this in 2018 when he was notified by Mr. Bedford's mortgage lender that Mr. Bedford was in a substantial amount of rent arrears, as I understand. Paragon then made an application to the first tier tribunal for determination that there had been a breach under section 168(4). And Mr. Bedford made an application to strike out on the basis that Paragon had waived their right to forfeiture because they had previously accepted, back in 2011, the acceptance of rent with the full knowledge that he was going to sublet the property. The first tier tribunal dismissed that application. Mr. Bedford appealed, and the upper tribunal dismissed that appeal. The summary of the judgment is that essentially why the first tier tribunal refused to strike out is because it considered it had jurisdiction to determine if a breach had taken place, but not whether there is a defence for forfeiture claim that may or may not follow. And even if there was a waiver, the first tier tribunal reasoned other remedies flowed from determination of a breach of a lease. And also the first tier tribunal held that they had no jurisdiction to make a determination as to whether or not forfeiture had been waived. And the upper tribunal considered that the first tier tribunal's use of consideration of alternative remedies actually was appropriate for the first tier tribunal to have in their mind. And you can see here an excerpt from the judgment from the upper tribunal where it states that I do not accept the availability of alternative remedies was an irrelevant consideration. Actually, in fact, it was highly relevant. And so in essence, the upper tribunal held that whilst the first tier tribunal had jurisdiction to make a determination on the waiver, it did not move the matter very much further, because in their consideration there was no abusive process. So they stated that there was a clear waiver, but there may have been a possible damages or injunction claim. I'm now going to turn and pass you to very capable hands of Andy, who's going to explain forfeiture and rent in more detail.
Thank you very much, India. Very capable, unless it comes to moving slides on one at a time. So sorry about any delays. Yes, forfeiture and rent. Before I start, can I just answer one question that came in from somebody booking, which was who has a right to reside upon a relationship breakdown? And it's also featured in some questions, and indeed India touched upon it in her presentation as well. I just wanted to just deal with it in two short parts. First of all, if one looks, for example, which I know is not directly on point, at succession, remember that whilst this isn't a short tenancy or shorthold tenancy, it has to be remembered that there is different provisions in section 17 of the 88 Act, which says that section 17(1)(b) says that if the landlord is a private registered provider of social housing, if the tenant is a sole tenant, and if the spouse or civil partner lives with the tenant at the time of their death, then it would go to the spouse or civil partner. So it does actually provide for that, even though it's not a periodic tenancy, which is what section 17(1) is primarily dealing with. Otherwise, if that doesn't happen, it will go through the will or intestacy rules. And that is unless there is an express term of the agreement providing otherwise. So the agreement itself can do that. You normally can't do it if the tenant was a successor, which is unlikely, or at least it's early days for that in terms of shared ownership, I think, unless again the agreement provides otherwise. So in short, in terms of a death of a tenant, if it's a joint tenancy, it will go to the joint tenant in the normal doctrine of survivorship way, not because of any act, because of that doctrine. If it's, let's say, a sole tenancy and the tenant dies, the owned part will obviously go under the will or under any intestacy rules. The rented part will go to the successor under section 17(1)(b) onwards. And it's the successor that has the right to occupy, I should stress, not the person, if it's a different person who's been given the owned part. If there is no successor, the person who has been left the owned part, let's say in a will, can apply for an order for sale. And if there is no beneficiary at all, then that will go to the Crown, the Duchy of Cornwall, or the Duchy of Lancaster. If, however, to answer the question, which I think Barry asked from Hammersmith and Fulham, if the sole tenant leaves the property, then of course you can't, as India said, use a notice to quit, because this isn't a periodic tenancy. You can't really say, well, you must quit your premises at the end of the 90-year period, can you? And it therefore is a forfeiture. But unlike ordinary tenancies, in the sense of periodic tenancies, of course, this isn't a case where, for example, if it's known your principal home case, you would serve a notice to quit and the tenant would have to get back before the expiry of the notice to quit, otherwise security of tenure would be lost. Or, as just been explained, section 15A for periodic tenancies would permanently end security of tenure if you sublet the whole. A tenant of a shared ownership lease can go in and out of security of tenure, and indeed Lois mentioned, I think, the case of Bupa and Tenancy and Metropolitan Housing Trust. And that was a case where she had been for many years subletting the property, and there was problems with potentially waiver. But luckily enough, she moved back into the property and we could use Ground 12 to get an outright order. So the answer really is that if there's a relationship breakdown, well, it's the same rules for assured tenancies if you are staying at the property. If it's not, and you're leaving the property, then of course there could be a problem. Bearing in mind, of course, that if you are a civil partner or a married person, then you occupy your property or the tenancy as if you are the tenant. So that has to be borne in mind. So that's just a bit of a starter, and if anyone has a question, that we have a question session at the end, so we can deal with questions then. Looking at some issues that have been come up, and indeed Lois mentioned this at the end of her presentation, we have the fact that when one looks at, well, why is it a question of notice seeking possession and such like, which has just been explained by India? Well, it's because section 5, subsection 1 of the Act says that an assured tenancy can't be brought to an end except by obtaining an order of the court, etc. And then section 45(4) makes it very clear, one would have thought, for the avoidance of doubt, it's hereby declared that any reference in this part to a power for a landlord to determine a tenancy does not include a reference to a power of re-entry or forfeiture for breach of any tenancy or condition of the tenancy. And if one needed just to be really kind of certain, one has the case of Artesian residential developments and Beck. That was a case where Mr. Beck was an assured tenant. Well, I don't know if it was Mr. or Ms. or whatever, but they were an assured tenant. They had arrears of a little over £2,200. The landlord took possession proceedings on grounds 8, the mandatory ground, or 10, and an outright possession order was made. Arrears were paid shortly thereafter, and I suppose recognising that there was no power to apply to suspend the possession order because of section 9, subsection 6 of the 1988 Act, which says that you obviously can't do that with mandatory grounds like ground 8. What they did was they applied for a suspension under section 138 of the County Court Act 1984, which is the relief from forfeiture in respect of rent. The district judge quite properly said, no power, I'm afraid, therefore. That's why they made the outright possession order. The circuit judge wasn't so informed and said, no, what a great idea. I'm going to apply section 138 and you can have the relief. And the Court of Appeal said, no, I'm sorry, but the Housing Act 1988, particularly the references I've just given you at section 5 and 45, rules out a forfeiture claim. And that therefore, so long as the agreement, and we know this, of course, from recent jurisprudence in cases such as in particular, London, Croydon and Colonga, which reached the Supreme Court, as long as there is a proviso, a forfeiture clause for re-entry, and that's a fairly wide definition, as one knows from that case, then it can be, you can certainly seek possession, but you can't do it by way of forfeiture while security of tenure remains. Once security of tenure has gone, that's different, because you're no longer restrained by section 5, you're no longer restrained by section 45, and therefore Artesian and Beck, which was obviously dealing with the statutory provision, is no longer relevant. So you may get arguments that, oh no, you should have gone for forfeiture, and indeed I'm involved in a case at the moment where they're claiming relief from forfeiture, even though their claim says, although there has been no forfeiture order, because it's a standard ground 12 possession order against a shared ownership tenant. But some people are very imaginative. The other issue which has come up, mainly through what you see under number 3, the Sovereign Network and East case, and that was a case which was initially badly reported, and eventually the Housing First got it right. It was basically a shared ownership case where ground aid had been obtained, ground aid possession order had been obtained, and sometime later, hadn't attended the hearing, there was an application eventually through various means to set aside. There's appeals and so on, but effectively it's to set aside a possession order. And one of the best judges around, Her Honour Judge Bloom, made a decision that it should be set aside. But that was largely because of perceived pre-action deficiencies. And this really labours and emphasises the point India was making, that with shared ownership, recognising that people have an investment in the property, it's important in any case, even with a periodic tenancy, to do a good pre-action process. It's particularly important with shared ownership cases, where you could otherwise be said, subject to the terms of the lease, to be coming into a windfall. So really, you've really got to make it clear to people who do realise you can actually lose your whole investment in this property. And that really needs to be made clear. And to some extent, it doesn't matter whether you go under the pre-action process set out in the protocol or whether you go under the practice direction. Just make sure that the tenant is made aware of the repercussions of the actions. The tenant is given the opportunity to explain the difficulties that they may be facing, and that there is at the very least clarity, so that one can't be said to be acting unfairly. The section 166 argument, which is the argument that excited, and it's probably said more for us than it does for anything else, but it certainly excited me, was an argument that said that if you have a long lease, what I would call an ordinary long lease of a property, which of course we're talking about flats here, if one has a long lease, one has ground rent. In other words, every year you pay an annual sum, £200, £300, sometimes more. And you have to have a section 166 notice, which is a prescribed notice, served before that's payable. If you don't serve that, then it's not payable. And there was an ingenious argument raised because of the Avon Ground Rents case that had been mentioned by Lois earlier, that, well, that must apply to a shared ownership tenancy because, as Avon Ground Rents said, section 76, which defines long lease, has been determined as defining it for the purposes of a shared ownership, whatever the staircase, and whether it's staircase to 100% or not, and that therefore section 166 must apply. Just a few responses to that, and I ought to say at the outset, my view is you certainly don't need to serve a section 166 notice to get your weekly or monthly rent. from a shared ownership tenant. And the reason is one needs to understand the ground rents case. Avon Ground Rents was a right to manage case. The shared ownership tenant had a long lease and hadn't staircased to 100%, and indeed a whole range of tenants hadn't, and therefore they hadn't been given notice by the right to manage company of the claim to acquire the right to manage. And it was then said, well, that's unfair because, and indeed it's unlawful because you've got to serve a notice on all qualifying tenants, and they are a qualifying tenant. And effectively what the Court of Appeal decided, and I hasten to add, it wasn't the one who came up with this brilliant idea. It had been previously determined in 2013, I think, by another court. It decided that Section 76 applied. In other words, the long lease definition of Section 76 subsection 2 applied whether or not you staircase, because as long as you satisfied one of the conditions. So, for example, A says a long lease if it is granted for a term of years exceeding 21 years. What it is, isn't it? That's what a shared ownership is. It's not a 5-year tenancy or 6-year tenancy that the industry got very excited about a few years and rightly dropped the idea. This is a proper, 90-year and increasingly, of course, much longer than that because of the reforms lease. So it comes under that. One might argue, well, what's the point of E, which says it's a long lease if it's a shared ownership lease, whether granted in pursuit of that part of that act or otherwise, where the tenant's total share is 100%. What's the point of saying that if it's going to be a long lease anyway? But that didn't seem to trouble greater minds than mine. And as I say, that was really just confirming the decision that we made in 2013 in a case called Cornerstone Barristers block and Rolex Limited. So it's not a new case. And I hasten to add, what that also means is it's not a new argument that the 166 notice should be applied by social landlords operating shared ownership leases. We've been quite happily ignoring that for the last 11 years. And as I say, I think there's good reasons why one would continue. And broadly speaking, my own view is that it's twofold. One is, I think 166 is very much applying for ground rents. In other words, in most shared ownership leases, you don't start paying ground rent until you staircase to 100%. In the meantime, you're paying subsidised rent on your share of the property, which you haven't purchased. And that's not what the purpose of Section 166 is. It's quite obvious that it's in relation to a much rarer annual payment. So, for example, the date on which the tenant is liable to make the payment must not be less than 30 days or more than 60 days after the day on which the notice is given. Well, that would be ridiculous if you have to serve that every week, between 30 and 60 days in advance. It just simply wouldn't work. So I think, and there's other arguments from the, you would have thought convincing, but it doesn't apparently mean it's convincing, argument that Section 166 is headed ground rent, but let's not worry about that too much. But also, as I say, the logic suggests that this is clearly a protection for tenants wrongly being taken for forfeiture because they weren't aware of their annual commitment, as opposed to, of course, for a weekly or monthly obligation which shared ownership tenants have, which of course they're aware of their obligation to do that and don't need the notice to allow them to do it. So I think there's a good argument to say that that's ground rent anyway. I also think that despite the right to manage decisions of Cornerstone and Avon Ground Rents, there is a very good argument that says, well, that's fine in respect of right to manage, and it very much is limited to the particular part of, I think it's part 2 of the Act, which deals with right to manage, but that doesn't apply to Section 166. And just to give you a very quick couple of examples, if you were to look at Section 167(5), which is to do with failure to pay a small amount, it defines long lease as has the meaning given by Section 76 and 77 of the Act, except that the shared ownership lease is a long lease, whatever the tenant's total share. Well, you don't need that definition if the definition is, as the Court of Appeal decided in Avon Ground Rents and Cornerstone Close. What's the point of that definition? You have the similar wording in Section 1695. You have a similar wording in Section 1715. So I think there are good arguments why you don't do it. I mean, there's an administrative impossibility of doing it anyway. But the reason why we wanted to focus so heavily on it today is, of course, it's the kind of thing which any enterprising young, new lawyer wanting to make their name is going to want to push. And particularly, you know, if you've got somebody at a duty advice desk, and I've done that myself, so I don't criticise them for it, it's going to raise it. There's a very interesting argument on this point. In my view, it's not that interesting, despite what I said earlier. And I just think it's, as I say, it's one of those things which initially panicked some of us. But I think when one looks at it with any kind of thoroughness, I think one can be confident that Section 166 doesn't apply to shared ownership leases in the context of having to recover their rent. So that's a very quick run through of where we are there. And this is the one I put out on social media just to say how ironic, eh? Obviously, I'm not the future by any means, the past, but what's that phrase? Who said I was the future once? Was that Blair or something?
I think so.
Anyway, whoever said it, it's certainly not me, but I am obviously joined in this webinar by the people who are. So, but what I wanted to say is that we do have the Renters' Rights Bill, which has just been renamed to the Renters' Reform Bill, which was available before the election. And that was, of course, the highlight of that was getting rid of Section 21. But in terms of shared ownership, it made a very simple provision, which was simply that fixed terms of more than 7 years cannot be assured tenancies. As you see there, under the old bill, which obviously died at the time of the election, it wouldn't affect existing possession orders of shared ownership cases, it wouldn't affect existing possession claims, and it wouldn't affect cases where a notice seeking possession had been served and that was still live. In other words, there could still be a possession action issued in reliance on it. And now, so if that is the case, then of course one's going to find that in the Renters' Rights Bill, and I'd see no reason why they would change that for the bill. There is some indication that we're talking about the turn of the year when it may be introduced. So it won't be that long before we'll know. But again, there will still be those residual cases you see there, which are likely to be still operating under the system that we've been explaining this morning. So it really is a question of watch this space, but I think it's going to happen. I should also say, by the way, that for local authorities, they do actually have something called a long tenancy exception in Schedule 1, unlike in Schedule 1 to the 88 Act. And a long tenancy is defined as a tenancy for terms certain exceeding 21 years. So it's a very similar idea that it's quite easy to exclude certain agreements from security of tenure, whether that's assured or secure. There is a voluntary code of practice consultation out at the moment, which I believe ends on the 9th of September, run by the Shared Ownership Council. And you can see there, it's seeking to raise standards, etc., improve consumer experience and so on. So worth having a look at that, albeit, as I say, we're very much at the tail end of that code of practice. It's my fault, it's my age. Any questions? Over to you, Lois.
Thank you, Andy. So we have quite a few questions coming in on Section 166. So I'll try and just group those together and hopefully we can deal with those together. So we have one attendee, Rebecca Sembuze, who said that they've had a client who had a lender insist on a Section 166 notice before they would clear arrears, and asked, perhaps in relation to that, whether there would be any disadvantage to a landlord in hedging their bets and using a Section 166 notice anyway before a notice seeking possession, even in circumstances where they don't apply as a mandatory thing.
Well, there's no disadvantage, save it's a very complicated process given what I explained. In other words, yes, in one sense, it's no difficulty giving out a prescribed notice. I mean, that's fairly straightforward. There's an administrative expense, of course, But as I say, when you look at the rules as to when it must be served, it makes sense for an annual charge. But just to say it again, it says at subparagraph 3 of section 166, the date on which the tenant is liable to make a payment, the rent must not be less than 30 days or more than 60 days after the days on which the notice is given. So it must be between 30 and 60 days on which the notice is given. Now, you know, it's just quite an administrative nightmare to do that. But no, I mean, you're absolutely right to say that if one served it, I mean, you know, yes, I suppose it does. It covers you from that argument. But I just think it can be an administrative nightmare, I think, for many providers, particularly with a reasonable stock of shared ownership properties. And I think you know, I think they're just you being cautious, probably. But yes, I mean, if they wish to do so and feel that it's a good use of money, that's fair enough.
Yeah. And that would all apply in the same way to council long leases as it would to registered provider properties.
Yes, although of course it's slightly different with local authority properties anyway, because they're generally excluded because of the Schedule 1 exemption there. But so yeah, we are primarily talking here about private registered providers, not registered providers.
Right, and great. I've noticed that there was a question quite a while ago now about the implications of the Renting Home Wales Act 2016 and how this might affect the position. What do we know about that? What can we say at this stage about whether it will affect?
This is the reason I said.
I see what you did there, Andy.
You see, that's clever, wasn't it? Well, what this means is I haven't got a clue. I mean, to be honest with you, a lot of people, you know, on all sides of the profession were involved in kind of doing things like drafting agreements, because of course there's some really good points that have come out of the Welsh reforms, and some very impressive points, and particularly on certain things like homelessness, very forward thinking. But to be honest with you, some of the kind of minutiae of it, and indeed just the renaming of, you know, it's not tenancy agreements anymore, of course. Anyway, it's just incredibly difficult. The reality is, I don't know the answer. I'm going to leave it and I'll alert them. So if the person wants to either join that or even just send me a message and I'll get the answer directly back to them, I will ask the experts who are Sarah Salmon and Alistair Cantor. Particularly Sarah has done so much work on this. She is the leading expert in the country on these reforms, as far as concerned anyway. I'm more than happy to do that. But as I say, if one wants to go on that, and I'll alert them to the fact there may be a question on shared ownership, I will. So I've bottled out that one.
Fantastic. We have had a couple of questions about the issue of security of tenure, and Helen Tucker very kindly informs us all that there's an express term prohibiting subletting in the current model of the standard shared ownership lease. So that obviously goes to the subletting point. There's a question about circumstances where security of tenure has been lost, how it could be regained in order to satisfy the Section 146 requirements. And I think we touched on this already to some extent, but in circumstances where security of tenure has been lost, what would be the best process for the landlord to follow to make sure that they're satisfying those Section 146 requirements?
Well, the big problem, of course, of forfeiture, maybe it's not a problem if you're more efficient than me, but it's waiver, isn't it? You know, that's the problem. Yeah, did you immediately say, okay, you no longer have a lease, you no longer have an agreement, you know, or did you accept rent or, you know, act as a landlord, etc. And that's the big problem. But it works both ways, of course, because, you know, unlike with a long lease, which is, you know, a proper long lease, which is not said ownership, which is always a forfeiture issue, it's never going to be covered by the 88 Act of 85 or 88. With shared ownership, you're going to have a situation where you can go in and out of security of tenure, not just for owning a principal home, which you can do anyway, of course, for periodic tenancy. You can go in and out of security of tenure so long as you get back to the property and live there as you own your principal home prior to the expiry of the notice to quit. And I did say to one questioner, have a look at Crawley and Sawyer for a really wacky decision where he actually had moved in with his girlfriend and then they split up, and he actually only moved back in after the expiry of the notice to quit, but he was still okay. So that was a very kind of generous decision by the court there. But the difference is, of course, with a periodic tenancy, not only do you have an automatic implied term, but as Helen says, you know, most modern leases have a term about subletting anyway. But unlike periodic tenancies, where you lose your security of tenure once and for all if you are sublet the whole and you cannot regain it, all you can do is be granted a fresh tenancy. And it's a bit of a warning if you're trying to be generous to people. That's all you can do. They've got a fresh tenancy. With a shared ownership, because that's expressly excluded from Section 15A of the Housing Act 1988, it means that whilst you've sublet the whole, of course, you've lost security of tenure because you're not living there, you're only principal home. It makes obvious sense. But once you move back, if you suddenly think, oh my God, they found out, I have to kick out the tenants and move back in, you know, putting aside there may be still doubts as to whether that's your principal home. If you genuinely move back in, then you can do it. And as I say, the example, and Bucher and Tenancy is a good example, you know, is one where there were periods where the forfeiture process may have had to be used, but there were periods, i.e. when she moved back in, that we were able to use Ground 12 and a breach of the subletting provision. Because it's always a bit odd that people say, you know, it's a Ground 12, which is you breached it by subletting the whole, because obviously with a periodic tenancy, that doesn't make any sense. Because if you sublet the whole, they've lost security of tenure, and therefore Ground 12 doesn't apply, because the 88 Act doesn't apply. You can just issue a notice to quit. As I say, shared ownership is different because you can go in and out of security, depending upon whether you effectively move back in. Which is why I wanted to leave it live to make that clear.
Absolutely, yes. And I'm conscious of time and that we've run over a bit. So unfortunately, I don't think we'll get to all of these questions, but there's two more, hopefully quite short, discrete points that it would be good to just quickly cover. So one question we have on whether or not the pre-action protocol for debt claims would apply in conjunction with the pre-action protocol for social housing. And then another question about the most appropriate avenue for a landlord in circumstances where a shared owner is causing significant ASB issues, and whether the most appropriate procedure for that would just be to serve a NOS as normal on grounds 12 and 14, as one would with any other assured tenant, or whether another process would be more appropriate. So hopefully we can deal with those in a minute or so each. But yeah, so the pre-action protocol for debt claims, does that apply? Does one need to follow it?
No, because although you're probably going for money judgment as part of it. It's not the claim, is it? The claim is possession, and therefore, if there is a protocol, it's going to be the social, social landlord protocol, and if there's not, it's going to be the pre-action. I would say with ground 12 and 14, it reminds me, of course, one of the reasons that people often go for injunctions with shared ownership matters. So if, for example, I found you subletting, I'm going to go for an injunction, is because you may have waived the right to forfeiture, but you may not have waived the breach of condition. And therefore you may still have an action by way of injunction. And there have been some very successful, effectively actions where they've got some compensation back as well from the tenant and an injunction. But with ASB, assuming they're living there and they're just being a nuisance and whatever, you would just go for a normal NOS or an injunction, ASB injunction, or, I don't see why it'd be any different. I think the only difference it would make, because they're shared owners, is just this thing about really making it clear, look, we gave them every opportunity, we didn't want to just, because it's obviously they've got an investment in it, but why should they be allowed to get away with things which, our periodic tenants would be allowed to get away with? But how you deal with it, I would deal with it no differently than I would deal with the periodic tenancy case personally.
Yeah, no, I
agree with it?
No, I completely agree.
Well, thank you very much. We'll wrap it up there because we're at 10 minutes past 12 and we've already overrun. those of you whose questions we didn't get to, we're very sorry we didn't get to answer them live. I've made a copy of your questions, so if there's anything urgent, we'll hopefully be able to inform you about that out of webinar. But please do come back again for the Renting Home Wales Act Big Issues and Appeal Points webinar. Join us for Housing Day. Thank you very much for attending, and have a lovely sunny Friday.